Hello and welcome to My Safety Hub, your go-to source for all things health and safety. Today we are diving into the world of the functions of the health and safety representative. Let's first have a look at the course overview. This course provides a comprehensive foundation for individuals elected as health and safety representatives, serving as the essential eyes and ears of the workforce. Participants will gain a deep understanding of the Occupational Health and Safety Act 85 of 1993, learning to navigate legal frameworks, employer and employee duties, and their own protection from civil liability while performing safety functions. Beyond legal compliance, the training introduces advanced models like the Frank-Burr triangle for proactive incident prevention and the mindset evolution schema to shift the workplace culture from mere instruction to a shared safety identity. By the end of this course, representatives will be equipped to conduct effective inspections and transform safety committee meetings into drivers of continuous improvement. This course is free for anyone to attend, but if you would like to receive a formal certificate for this, please feel free to use the first link in the description below to purchase your certificate. Upon the purchase, you will receive a direct link to the virtual assessment, login details, as well as a formal training manual and direct support from myself. Once you've completed the assessment, a virtual certificate will be automatically issued to you. Let's start off with the Occupational Health and Safety Act 85 of 1993. This is to provide for the health and safety of persons at work and for the health and safety of persons in connection with the use of plants and machinery, the protection of persons other than the persons at work against hazards to health and safety arising out of or in connection with the activities of persons at work, and to establish an advisory council for occupational health and safety and to provide for matters therewith. In other words, this is the overreaching goal of the Occupational Health and Safety Act, and this is to provide for the health and safety of three groups of individuals, namely your employees, contractors and visitors, and members of the public. Now let's further break this down into the legal framework of health and safety. The Occupational Health and Safety Act, or OHS Act for short, and related legislation delineates the responsibilities for both employers and employees in ensuring workplace safety. This also is evolving alongside technological advancements. This legislation aims to maintain pace with changing workplace environments and associated risks. Now, a big question that needs answering is, what is a health and safety representative, or SHE Rep in short? A health and safety representative is a fundamental link between employees and management. A health and safety representative is also called an employee representative because they take the best interests of the employees to heart, specifically in a health and safety context. Think of them as the eyes and ears of the workforce regarding safety. They are employees elected by their peers to ensure that the workplace remains safe and the environment remains coherent. The SHE Rep is a representative that covers safety, health, and environmental hazards, hence the abbreviation SHE Rep. They are also charged with ensuring safety in the workplace. SHE Rep duties include proactive employee training, protection from workers from potential hazards, and communication about accidents and incidents, and inspections and auditing of safety measures. Now, before we break down the functions of the health and safety representative further, we must first take a step back to understand some key definitions. So understanding the terminology is of utmost importance. The Act provides a comprehensive definitions for crucial terms, ensuring clarity and consistency in its applications. Definitions encompass various aspects, from accidents and hazards to responsibilities of employers and employees. Now, please note, it is vital for you to peruse and understand the terms and definitions contained in and applicable to the Act for its application and compliance. Now, the first term that we are going to be defining is called as far as reasonably practicable. As far as reasonably practicable is a legal and safety standard requirement for employers to eliminate or minimize risks to the lowest level achievable, balancing the severity of the risk against the cost, time, and effort involved in removing said hazard. It requires taking all necessary steps unless the cost is grossly disproportionate to the safety benefit. Next, we are defining one of the cornerstones of health and safety, and this is a hazard. A hazard is any source, situation, or act with the potential to cause harm, including human injury, illness, property damage, or environmental damage. Hazards represent potential dangers, for example, a wet floor or an extension cord across a walkway, while risks, on the other hand, is the likelihood that the hazard will cause harm. They are often categorized as either physical, chemical, biological, or ergonomical hazards. Now, let me give you a practical example of a hazard. Think about the following situation. In your workplace, you have an extension cord lying over the walkway to your desk. On one particular day, you walk to your desk, your foot gets caught on that loose extension cord, you fall down and break your arm. If I now have to ask you, what caused you to fall down and for that injury to happen, your answer will most probably be the extension cord on the floor, and you are quite right. That extension cord laying on the floor is deemed a hazard. It is the thing or the source that caused damage to you. On the flip side of this coin, we look at risk. Risk is the uncertain possibility that an event will cause harm or loss, or a deviation from a desired objective. It combines the probability of an occurrence with the magnitude of its impact. Risk is distinct from a hazard, which is the source of the potential harm, while risk is the likelihood that that hazard will in fact cause harm or damage. Now, to put this into perspective, the extension cord on the floor in itself is not going to cause the damage to you. There is a potential of damage, but we must first make contact with that specific hazard. And further to this, when we make contact with the hazard, now all of a sudden we have multiple risks attached to that one particular hazard. We have a risk of falling down and potentially injuring our arm. We have a risk of falling down and potentially bracing ourselves. We have a risk of falling down and potentially even dying. So it is fundamentally important that we understand that for every single hazard present, there will be multiple possible risks attached to that one particular hazard. Again, the risk is the possibility that different types of damages can and most probably will occur. Now, in order for a hazard and a risk to realize, something must happen. And this something that happens is what we call an unwanted event. In health and safety, an unwanted event is an unplanned, unexpected, and undesirable occurrence that breaks the normal work routine when someone or something comes into contact with the hazard and has the potential to cause or actually does cause harm to people, damage to property, negative environmental impacts, or business interruptions. As I've mentioned, the extension cord on the ground in itself doesn't pose any threat to you. We must first make contact with a specific hazard, in other words, the extension cord, for those risks to be able to realize. So again, our foot getting caught in that extension cord is a primary example of an unwanted event. If our foot never gets caught in the extension cord, the risk of me falling down and breaking my arm doesn't exist yet. So an unwanted event is the first part of this sequence. Making contact with the hazard. Once we've made contact with the hazard, then the risks start to realize. So in other words, unwanted event to the hazard to the risk. Now, the outcomes of this sequence of events is called accidents or incidents. Now, they might sound very similar, but the fact of the matter is that they are different. An accident is the unintentional, unexpected event that results in injury, damage, or harm. An incident is a broader term for any, and often minor, unexpected events or occurrences that may or may not cause harm. While all accidents are incidents, not all incidents are accidents. And this is where we get introduced to something called a near miss. Now, it is important for us to understand that when we speak about risks, both accidents and incidents are classified as potential risks, or an outcome rather of those potential risks. So, for example, you walk down the walkway, your foot gets caught on the extension cord, unwanted event. You start falling down. You've now made contact with the hazard. Now we have multiple possible outcomes or risks. You can either fall down and break your arm, accident, or you can fall down and brace yourself on the adjacent desks, not causing any physical damage to you, which is an incident or a near miss. The common denominator between an accident and an incident is that unwanted event. It is still something that happened, but with two different outcomes. Now that we understand the sequence of events from the unwanted event, making contact with the hazard, and the possibilities of different risks, we need to take a step back to understand what causes these accidents and incidents to actually happen, or at the very least, what causes the unwanted event to happen. The first contributing factor here is what we call unsafe acts. An unsafe act is a human action that violates safety procedures, ignoring rules or taking risks that directly increase the likelihood of accidents or injuries. These are all behavioral fails, such as bypassing machine guards, not using PPE, or rushing that can frequently cause workplace incidents. In other words, an unsafe act is people knowingly doing something they are not supposed to do. Our next contributing factor is what we call an unsafe condition. An unsafe condition is a physical, environmental, or operational hazard in the workplace that can cause incidents, injury, or death, regardless of employee behavior. These are dangerous situations such as broken tools, poor lighting, or unguarded machinery, rather than human actions. Common examples include slippery floors, exposed electrical wiring, and inadequate ventilation. Now, it is very important that we understand that both unsafe acts and unsafe conditions can cause one another. For example, if you work in a crowded warehouse and you are tasked with welding and grinding activities, and you do not take the necessary precautions, you are essentially committing an unsafe act by not having the screens in place, not wearing your PPE, and so forth. So yes, you are contributing to an unsafe act. However, by you performing that unsafe act in the crowded warehouse, your actions are directly affecting the employees around you. Thus, your actions creating an unsafe condition of flying debris, heat, and so on. So by you doing something wrong, you are contributing to an unsafe condition as well. Vice versa, if there is an inherent unsafe condition, for example, a noisy area, and you choose to work in that area without the proper protection, then you are also committing an unsafe act by entering into the unsafe condition. So once again, to remind that unsafe acts can cause unsafe conditions, and unsafe conditions can cause unsafe acts. Now, the next important definition is employer versus employee. It might sound a simple concept, but it is crucially important that we understand the difference. An employer is an individual or organization that hires, pays, and supervises workers, holding responsibility for business operations and safety. An employee, on the other side of the coin, is an individual hired to perform specific tasks in exchange for remuneration, acting under the employer's direct direction. The core difference is authority, risk, and the compensation structure. So in short, if you provide an instruction in return for remuneration, you are deemed an employer. If you receive an instruction in return for remuneration, you are deemed an employee. Now, we've spoken about the contributing factors towards accidents and incidents, and I just wish to reiterate them here. We spoke about unsafe acts and unsafe conditions, but here we can see that 88% of all causes of accidents and incidents are as a result of unsafe acts, people knowingly doing something they're not supposed to. Unsafe conditions only contribute at 10% because most unsafe conditions are caused by unsafe acts. And lastly, we are now introduced to acts of providence, or in other words, acts of nature. And again, this only contributes a 2% to all accidents and incidents. This being said, 98% of all incidents can be prevented due to the fact that these causes of those incidents are things people do wrong in the workplace. Next, I want to introduce you to the Frank Bird Triangle. The Frank Bird Triangle, also known as the Bird Safety Pyramid or Accident Triangle, is a statistical model used in occupational health and safety to show the relationship between the frequency and the severity of workplace incidents. This was developed by Frank E. Bird Jr. in 1966 after analyzing over 1.7 million accident reports. It evolved from the earlier 1931 theory by H.W. Heinrich. Bird's vision is more comprehensive and is still used today as a cornerstone for modern safety management systems. Now, the first concept in the Frank Bird Triangle is what we call the 1-10-30-600 ratio. The triangle is defined by a specific set of ratios. Bird proposed that for every one major incident, there are hundreds of smaller and often ignored events that precede it. So the 1 stands for serious or major injury, a fatality, permanent disablement, or lost time injury. The 10 stands for minor injuries, incidents requiring first aid or medical treatment but resulting in no significant lost time. The 30 stands for property damage incidents. These are accidents where equipment or materials were damaged but no people were hurt. And ultimately, the 600 stands for near misses or incidents. These are events where an accident almost happened, but by luck or quick reaction, no injury or damage occurred. So by virtue of this ratio, it tells us that for every one serious accident, there will be up to 600 near misses. And those 600 near misses is where the trick lies. If we focus on those 600 near misses or small incidents first, we cut down on this ratio drastically, because at that point, they are accident indicators. They haven't happened yet, but they indicate that an accident is on the rise. And if we nip it there and then, we prevent that 1 from creeping up on us. So why is this ratio important to the SHE Rep? This is where we talk about proactive versus reactive. Most companies only react when that 1, the fatality, happens. But Frank Bird theory argues that if you focus on the 600 near misses at the bottom, you naturally shrink that triangle, making the 1 at the top much less likely to occur. The foundation of prevention is what we will be looking at next. By investigating a trip over a loose cable or a near miss, You prevent the broken leg, that minor injury, or the fatal fall, which is the major injury that would have happened eventually. So in other words, accidents are measured in time versus probability. And Frank Bird further went on to say, the longer you do something unsafely, the more likely it is that it will result in an accident. So if we follow the steps and focus on those 600 near misses, we can camp that before the prolonging of time and it reaches an accident. Next, we are going to look at reporting culture. It highlights the need for employees to report everything, even if no one got hurt, because those 600 near misses are again early warning signals of potential major accidents. So reporting the near misses and the small stuff becomes fundamentally important, not only for the health and safety representative, but also for the employees. An employer or health and safety rep cannot do something about those near misses if they don't know that they actually exist. Now that we understand that concept, let's dive into the responsibilities of the employer as per the Occupational Health and Safety Act. Starting off with Section 8, the general duties of employers to their employees. This says, the employer must provide and maintain a working environment that is, as far as reasonably practicable, safe and without risk to the health of his employees. They must provide and maintain systems of work, plant and machinery that are safe and without risks to health. Take such steps to eliminate or mitigate any hazard or potential hazard to the safety or health of employees before resorting to personal protective equipment. Ensure that the safety and absence of risk to the health in connection with the production, processing, use, handling, storage, or transport of articles or substances. And most importantly, establish what hazards to the health and safety of persons are attached to any work which is performed or any article or substance which is produced, processed, used, handled, stored, or transported. And lastly, provide such information, instruction, training, and supervision as may be necessary to ensure the health and safety of his employees at work. If you would like me to break the OHS Act down further, specifically sections 8 to 14 and beyond, be sure to go and have a look at our OHS Act for Management training course. Next, we are diving into section 13, the duty to inform. And this says the following. As far as reasonably practicable, ensure that every employee is informed of hazards to their health and safety related to their work and any plant or machinery that they use, and the necessary precautionary measures for those hazards in question. Now, how do we do this? This is all based from your risk assessment. This is the most efficient way to communicate those hazards, risks for all the tasks the employees perform. So if we communicate the risk assessment to the individuals, we are successfully completing the first part of section 13. In addition to this, the employer must inform the relevant health and safety representatives beforehand of any inspections, investigations, or formal inquiries an inspector has notified you of, and any exemption applications under Section 40. So for you as the health and safety rep, it is important that you keep in mind that when the inspector from the Department of Labor visits your premises, the employer must inform you of such. Further to that, the employer must also inform the health and safety representative as soon as reasonably practicable of an incident in their designated workplace or section. So again, in order for you to perform your functions effectively and correctly, you will rely on the employer to inform you of any accidents or incidents in your respective workplace. We then move into section 14, the general duties of employees at work. We've now discussed section 8, which was the employer, and now we're moving to the employees. And this says the following. Every employee must at work take reasonable care for their own health and safety and that of others affected by their actions or omissions. So this now tells us that we are not just looking after our own health and safety. We need to look after our fellow colleagues and our fellow employees' safety as well, for both things that they do, the tasks, or things that they don't do or say, the omission side of things. Further to this, we must cooperate with the employer or other person regarding any duty or requirement imposed by this Act. In other words, if the employer asks you to do something or the health and safety representative asks an employee to do something, the employee must cooperate with that lawful instruction in order for the respective party to be able to carry out their work. In short, the employees cannot restrict you from carrying out your health and safety rep duties. Further to that, you must also carry out a lawful order and obey the health and safety rules and procedures set by an employer or authorized person. Now, the employer will set aside policies and procedures dictating what the employees must do and what rules they must follow. But further to this, it says that they must also follow the procedures of an authorized person. That authorized person can also be you as a health and safety rep. So if you are required to do a toolbox talk, for example, the employee must comply with that request. Then report any unsafe or unhealthy situation to the employer or to the health and safety representative as soon as practicable. This is the first glimpse that we see of that bridge we spoke about, where you bridge the gap between the employee and the employer. So in a situation where any unsafe condition or any unsafe act is taken place, the employee may report that directly to you as the health and safety representative. However, once you receive that information, you must relay that through to the employer as well. And then lastly, report any incident affecting their health or causing injury to the employer, authorized person, or health and safety representative as soon as practicable, but no later than the end of the particular shift, unless circumstances prevent it, in which case they must report it as soon as possible thereafter. So here we can see that all employees must report any incident or accident that affects their health and safety, and they can also report this directly to you. And then once again, if it's reported to you, then you will report it to the employer. We then move into one of the shortest sections within the OHS Act, and this is section 15, the duty not to interfere with or misuse things. And this quite simply says, no person shall intentionally or recklessly interfere with, damage, or misuse anything which is provided in the interests of health and safety. This includes your signs, first aid boxes, fire equipment, and even personal protective equipment. It is important for you as a health and safety rep to know that no employee may damage any company property provided in the interest of health and safety. We then move into section 16, the Chief Executive Officer charged with certain duties. Section 16.1 says the Chief Executive Officer or CEO must, as far as reasonably practicable, ensure that the employer's duties under this Act, namely Section 8, are properly discharged. So their core function is making sure that everything we spoke about in terms of Section 8 gets discharged. If they don't, the 16.1 can also be in the firing line and be liable for that as well. Section 16.2 says, without lessening their own responsibility or liability, a CEO may assign any of these duties to a subordinate who must act under the CEO's control and direction. So what this section tells us is that the Section 16.1 or CEO may appoint what we call a Section 16.2. This 16.2 is essentially a second in charge, or a right-hand man or woman, as we would say. And this 16.2 is designated to also assist in the discharging of Section 8, as exactly the same as we spoke about in Section 16.1. Now, it is important we understand that a Section 16.2 can be any person that the CEO deems fit or worthy to be a 16.2, as long as they understand they share the same liability and accountability as the Section 16.1 or CEO. Then further to this, Section 16.1 says, Section 1 does not relieve the employer of any responsibility or liability under this Act, subject to Section 37. In other words, the Section 16.1, 16.2, and even Section 8 cannot contract out their liability or responsibility. It doesn't matter if you contract someone to assist you with the implementation of your health and safety system, you cannot contract out the liability or responsibility to a third party. And lastly, for the purpose of subsection 1, the head of state department is considered the chief executive officer of that particular department. We are now diving into the most important sections within this presentation, starting off with section 17, the health and safety representatives. Now, in short, this section depicts when and how we must appoint health and safety representatives. So let's first start off with the designation of health and safety reps. From a requirement perspective, employers with more than 20 employees at a workplace must designate health and safety representatives in writing within 4 months of this Act's commencing business or exceeding 20 employees. In other words, if you have more than 20 employees, you must appoint your first health and safety representative. If you have less than 20 employees, you don't need a health and safety representative. Further to this, we are looking at consultation. Employers must consult with employee representatives or employees in good faith on the nomination and election term of office and designation procedure for their health and safety reps. Now, it is extremely important that we understand that the nomination and election process for a health and safety rep must be a very diplomatic process. We cannot just simply dictate who they are going to be if we feel that this person is the best fit, or irrespective of any of those criteria, the health and safety representatives must be chosen by the employees. So, if consultation fails, the matter goes to arbitration by a mutually agreed upon person. If parties fail to agree on arbitration within 14 days, the employer notifies the president of the industrial court, who in consultation with the chief inspector will then designate a final arbitrator. Then, in terms of arbitration, subsection 3, arbitration is exempt from the Arbitration Act, and consultation failure is not a dispute under the Labour Relations Act. The minister may prescribe the manner and the remuneration of the court-designated arbitrator. Next, we look at the eligibility of the health and safety reps. Only full-time employees familiar with the specific workplace conditions and activities are eligible to be health and safety representatives. So if there is a nomination and election process, and one particular person was nominated and elected for a specific department, but they are not well acquainted with that department, they do not qualify to be a health and safety rep for that specific department. Someone else that is more acquainted will need to take their place. The same goes for casual and contract workers. We cannot nominate and elect any employee who is not a permanent employee. Then we are going to look at the minimum numbers of health and safety representatives. So after the initial 20 that we spoke about in subsection 1, it scales. And the first scale is for shops and offices. And this says at least one health and safety rep needs to be appointed per 100 employees or part thereof. So in other words, if you have 200 employees, you will need 2 health and safety representatives. In all other workplaces or more industrial settings, at least one health and safety representative for every 50 people or employees needs to be appointed. Further to this, employees working away from their ordinary reporting location are deemed to be working at their reporting location. So wherever the employee is based, that will be the part of work where they can be nominated and elected as a health and safety representative. Next, we also have the inspector's direction under subsection 6. If an inspector finds the number of health and safety representatives, even in a workplace with 20 or fewer employees, inadequate, they may direct the employer in writing to designate a determined number of additional health and safety reps following the procedures of subsection 2. So although you might be complying to the minimum legal requirements, 1 for 100, 1 for 50, and so forth, if their inspector feels that it is inadequate, they may direct the employer in writing to appoint more than the minimum legal requirements. Lastly, we have the working hours of the health and safety representative. All SHE Rep activities, including designation, function, and training, must occur during ordinary working hours and are considered time spent performing employee duties. So, to summarize section 17, once you reach your first 20 employees, you must have at least one health and safety representative. If you are a larger organization in a shop and office environment, it scales to 1 for every 100 individuals. If you find yourself in a more industrial operation, you need 1 for every 50 individuals. The health and safety representatives must be full-time employees, they must be acquainted with the workplace, they must be formally nominated and elected through the employees or employee representatives. Further to that, once they have been verified, they must be formally trained and they must receive a letter of appointment to finalize their designation as a health and safety representative. Now that we've finalized the appointment of the health and safety representative, let's have a look at what they actually need to do. And this is depicted in section 18, the functions of the health and safety representative. And this says, a health and safety representative functions for the designated workplace include the following. Now, as a reminder for you as the SHE Rep watching this video, this will be applicable to you, and these are the things that you need to carry out on regular intervals. First and foremost is reviewing health and safety measures. These are essentially your control measures from the risk assessment. So if a risk assessment has specific controls, things like safe operating procedures, signages, and so forth, you have the responsibility to not only verify them, but also to review their effectiveness to see if they are actually working in real life. You can then also identify potential hazards and major incidents. So this allows you to conduct continual risk assessments, identifying those hazards, the things that can hurt you on a day-to-day basis that your task-based or baseline risk assessment might have missed. And further to that, you can also identify those major incidents, that 600 we spoke about during our Frank Bird triangle. Then also collaborating with the employer to examine incident causes. So when an incident does happen, you can be a part of that investigation to determine the root causes and the unsafe acts, the hazards, the risks, and so forth. This is all in an attempt to identify and prevent it from happening again. You may also investigate employee health and safety complaints. So as we now know, an employee can report certain situations directly to you. And if they do report it to you, you have the authority to do an investigation on that complaint, again, to try and determine the root cause of that complaint. You may then also make representations to the employer or safety committee or an inspector if the recommendations to the committee or employer are unsuccessful based on points 1 to 4. So let's say, for example, you've identified new hazards, you've investigated employee complaints. You can now take that information and go and present it to the Health and Safety Committee or directly to the employer based on your company's circumstances on items that have affected the health and safety of the worker. And now you need to have a plan in place to rectify that. So that is how you make representations on the matters from 1 to 4. You may also make representations to the employer on general employee health and safety matters. So again, if an employee comes to you with matters concerning health and safety, you may take that matter up to the employer themselves to seek remedial action. Then your staple is inspecting the workplace, including articles, substances, plant, machinery, or equipment. This is all done at agreed intervals after giving the employer reasonable notice. The employer may be present during those inspections as well. Now, I say this is your staple because this is a constant thing that you as the health and safety representative must perform on a regular basis. Industry good practice is that your inspections get done at least once a month. This is a formal inspection where you physically inspect your workplace for any deviations, hazards, complaints, near misses, and so forth. Once you've completed your formal inspection, we now understand you can make representation to the Health and Safety Committee, which we'll break down a bit later, or to the employer directly for any remedial action. Participating in and accompanying inspectors in the workplace, consultations and inspections. So it is important to understand that when you receive a visit from an inspector from the Department of Employment and Labor, that you can accompany that inspector during their visit. You may also then receive any information from those inspectors as per Section 36. So these are any notices, fines, penalties, and so forth. You may then also attend a health and safety committee if your company has established a health and safety committee. Further on the functions of the health and safety representative, you may also visit incident sites at all reasonable times and attend any in loco inspection, investigation, or formal inquiry held under this Act. You may inspect any required document the employer keeps under this Act as reasonably necessary to perform your functions. So in other words, if you require a machine manual or you require an inspection from a different department, the employer must make any health and safety related document available to you, provided that it aids in the performance of your function. Then you also may be accompanied by an inspector on any inspection. So if you are conducting your own monthly inspections, you may request the participation from an inspector from the Department of Labor for assistance reasons. You may also be accompanied by a technical advisor on any inspection with the employer's approval. So if you are designated for a certain department and you are not too familiar with a specific machine, for example, you may co-opt a specialist to accompany you during your monthly inspection, especially if there are hazards that you might not be sure about or some technical knowledge that you need advice on. Then you may also participate in any internal health and safety audit. And an employer must provide reasonable and agreed upon facilities, assistance, and training for the representative to carry out their functions. In other words, the employer must accommodate you to perform your functions as the health and safety representative. And lastly, a health and safety representative does not incur any civil liability solely for failing to do anything permitted or required by this Act in their role as a health and safety representative. Next, we are diving into the health and safety committees as per Section 19 of the Act. An employer must establish one or more health and safety committees at each workplace where there are two or more designated health and safety representatives. At committee meetings that must be held at least quarterly, the employer must consult with the committee to initiate, develop, promote, maintain, and review employee health and safety measures. So in short, as soon as you are two or more health and safety representatives, you must establish a health and safety committee. This health and safety committee must legally meet once every 3 months. Now, it is also possible for the employer to establish more than one health and safety committee. For example, if there are different shifts, then each shift might have a committee. So it is possible to have more than one committee. However, the health and safety representative must be a part of at least one of those health and safety committees. Now, a health and safety committee's size is employer determined, provided that if one committee exists, all health and safety representatives are members of that committee. If multiple committees exist, each representative is at least on one of those committees, as we've mentioned. And employer-nominated members cannot exceed the number of health and safety representatives. Employer nominees are designated in writing for a set period, and health and safety representatives serve for their designation period as per Section 17. Now let's just take a quick step back to these employer representatives. Who are they and how do that work? An employer representative is exactly what it sounds like. It is a representative representing the employer's best interests. Remember, you as a SHE rep represent the employee's best interests. So to keep the committees fair and diplomatic, the employer can choose to appoint employer representatives. However, these employer representatives can be equal or less as long as they are not more than the serving health and safety reps on that committee. So for example, if you are 5 health and safety representatives, the employer can appoint up to 5 employer representatives. They can have 1, 2, 3, 4, 5, or nothing, as long as it doesn't exceed the total amount of health and safety representatives. Further to this, the employer representatives will serve a specific time frame. This is normally, and industry best practice is, a year for their appointment. So they will serve for 12 months. However, the health and safety representative will serve their full term as per their nomination and election process that we spoke about in section 17.1. This might be longer, this might also be 1 year, but this is dependent on what the criteria is during the nomination and election process. Now, health and safety committee meetings again must occur at least quarterly or more often if necessary, at a time and place the committee determines. This is very important. The health and safety committee determines when and how often they meet, given that they meet minimum legal requirements. An inspector may direct a meeting to be held, or if over 10% of employees requested in writing, to an inspector. What this means is the inspector from the Department of Employment and Labour may also intervene and say that you must meet more often if they feel the minimum 3 months is not enough. Or if more than 10% of the employees request the Health and Safety Committee to meet more often, then they must also comply with those employee requests, because again, the SHE rep serves the employees. The committee may also co-opt advisory members purely for their knowledge of health and safety matters. Now, if you are sitting in the Health and Safety Committee and you are making representation on a hazard, for example, but you are not too certain on the rectification that must take place for this hazard, you may co-opt a specialist in that particular field to guide you to a more suitable resolution. However, these co-opted members cannot vote. Speaking about voting, The Health and Safety Committee needs to be a fair and diplomatic process. Now, the reason we must vote is because that a health and safety rep might have a different resolution to a problem as opposed to the employer representative solution. When there is a dispute in resolutions and your formal recommendation, all of these recommendations must be laid out on the table, and then a vote will take place to seek the most efficient solution that will then be represented to the employer to action. And last but not least, if an inspector deems the number of committees inadequate, they may direct the employer to establish more health and safety committees. Now that we know how a health and safety committee is structured, when they need to meet, how the voting process takes place, and how the representations are made, let's have a look at the functions of the Health and Safety Committee depicted in Section 20 of the OHS Act. A Health and Safety Committee may make recommendations to the employer or to an inspector if unresolved regarding workplace health and safety matters. So the purpose of the Health and Safety Committee is to identify any deviations, hazards, accidents and incidents and so forth. Put them on the table for the Health and Safety Committee and then vote for a reasonably practicable and efficient recommendation. That recommendation then needs to be made to the employer or may be made to an employer if deemed necessary to action. If that recommendation is brought to the attention of the employer has a responsibility to act on that recommendation. If the employer doesn't act on that recommendation, the Health and Safety Committee may take that recommendation directly to an inspector from the Department of Employment and Labour to seek advice and assistance from them as well. Further to this, the committee must discuss incidents where a person was injured, became ill, or died and may report in writing to an inspector if they deem it necessary. So this is a core function of the Health and Safety Committee. They discuss incidents and accidents, once again to seek a possible resolution to ensure that that accident or incident doesn't happen again. They may take that formal recommendation on the remedial action to the employer to action, and yet again, if those recommendations to the employer fail, they can take it directly to an inspector from the Department of Employment and Labour. The Health and Safety Committee meeting must also perform other prescribed functions. The committee must record all recommendations made to the employer under subsection 1 and all reports made to the inspector under subsection 1b. So in essence, all formal recommendations we spoke about on the first point and on the second point must be documented and kept safe for a period of 3 years. The committee or its members do not incur civil liability solely for failing to perform a required or optional duty under this Act. And lastly, the employer must take prescribed steps to ensure that the committee complies with Section 19.4 and performs the duties under Sections 1 and 2. So to circle back to that, the committee must meet at least once every 3 months, and it must perform the above 2 duties every single time they meet. We are now diving into Section 24, report to the inspector regarding certain incidents. Now, we spoke about incidents and we spoke about accidents, but we need to keep into consideration that there are 2 types of accidents and incidents. The first of which is what we call a common accident or incident. These are situations that can be handled internally by the health and safety representatives, the employer, the first aider, and so forth. These are things like minor cuts, bruises, or near misses. However, the second part is a Section 24. Now, Section 24 accidents and incidents are deemed of such a severe nature that they must be reported to the Department of Employment and Labour. Now, further to that, any incident at work or related to work activities, plant or machinery must be reported to an inspector by the employer or user if it results in the following: death, unconsciousness, loss of a limb or part of a limb, injury or illness likely to cause death, a permanent physical defect, or the inability to work for at least 14 days. Those are all Section 24 accidents. Then we also have when a major incident occurred. Now, these dangers to health or safety incidents involve the following: spilled or dangerous substance, uncontrolled release of substance under pressure, fractured, failed machinery causing flying, falling, or uncontrolled moving objects, or runaway machinery. If an incident causes death, likely death, or loss of a limb or part of a limb, the site, article, or substances involved shall not be disturbed or removed without an inspector's consent, except to prevent further incidents, remove the injured or deceased, or to rescue people. So in other words, if a Section 24 accident or incident exists, it must be reported to the Department of Employment and Labour as soon as reasonably practicable, but trying not to do so later than the end of the particular shift. And the scene may not be disturbed unless it is to remove the injured or deceased or to rescue people. The scene may only be cleaned up or disturbed once the inspector has given their go-ahead. Sections 1 and 2 do not apply to traffic accidents on public road, incidents in a private household, provided that the householder reports it to the South African Police Service immediately, or accidents investigated under Section 12 of the Aviation Act. Now, what happens if we do not comply with these different sections within the OHS Act? There are real-life repercussions depicted in terms of Section 38, Offences, Penalties, and Special Orders of the Court. So any person who violates to comply with the following sections, fails to comply with the direction or notice under the following sections, or fails to comply with an exemption condition under Section 14, a person who willfully provides false material, information, or any act-related document, any person who obstructs an inspector's function, any person who fails to comply with an inspector's requirement or requests to the best of their ability, fails to answer an inspector's question to the best of their ability, willfully provides false or misleading information to an inspector, falsely claims to be an inspector, fails to attend or remain in attendance after being subpoenaed under Section 32 without sufficient cause, tampers with or discourages, threatens, deceives, or unduly influences any person regarding evidence or production of documents or things before an inspector under Section 32, influences or anticipates the proceedings or findings of an inquiry under Section 32 or Section 33, tampers with or misuses safety equipment provided by the employer or user, fails to use the provided safety equipment at work or the plant or machinery, willfully or recklessly acts at a workplace or with plant or machinery threatening the health or safety. Now, if any person who does any of the above mentioned items, they may be guilty of an offence and liable to a fine not exceeding 50,000 rand or imprisonment not exceeding 1 year or both. So once again, if you contravene the Act in any of the above mentioned items, you can be held liable for 50,000 rand, 1 year in prison, or both. Further to this, any employer or user who acts or omits causes injury to a person at work or in the course of employment is guilty of an offence if that act or omission would have constituted culpable homicide had it caused death, regardless of whether the injury has been fatal or not. They may be held liable to a fine not exceeding 100,000 rand or imprisonment not exceeding 2 years or both. A court convicting a person for failing to comply with this act or notice and direction may, in addition to punishment, order compliance within a period determined by the court. When an employer is convicted of contravening Section 23, unlawful deductions, the court shall determine the underpaid amount and act in accordance with Section 28 and 29 of the Basic Conditions of Employment Act. Now, circling back to the functions of the health and safety representative, we spoke about your staple, which was the monthly inspections that we spoke about. Now, further to this, we are going to talk about physical workplace inspections. This is the most critical monthly task. Section 18 of the Act mandates that you inspect your designated area of responsibility. Now, how do we do this? We can do this with a walkthrough. Physically walk through your department. Look for blocked fire exits, frayed electrical cords, leaking chemicals, or poor lighting. You can do this through checklists using a standardized inspection form. This provides the paper trail, proving that the inspection actually took place. And lastly, equipment checks are vitally important. Ensure fire extinguishers are pressurized, first aid kits are stocked, and machine guards are in place. Here is a very nice example of a formal health and safety rep checklist, which I will leave on the screen for your reference. Now let's look at risk assessment and hazard reporting as a health and safety rep function. Safety isn't static. Things change, and each month you should do the following. Identify new hazards. Did a new machine get installed? Are there new chemicals being used, and are there new processes being followed? Then you need to submit a written report. If you find a hazard, you must report it to the employer or to the Health and Safety Committee in writing as per Section 19 and Section 20. Then a very important step that most health and safety reps miss. This is the follow-up. Check if the hazards you reported last month were actually fixed. If not, it is your responsibility to raise them again. Your primary function after the fact is to follow up and ensure that the report and recommendations get followed through and those hazards get addressed. One of the big things you need to do as well is the incident and near-miss review. Besides waiting for a big accident to happen, remember we said those small near misses can severely cut down on that sequence. So near misses cannot be overlooked. Using the Fran-Bird triangle logic, you should review everything that went wrong in the last 30 days. Participate in investigations of any injuries or near misses that occurred in your section. Make sure that you are aware of those near misses. And then start identifying trends. Are people tripping in the same hallway every week? Is a specific team constantly forgetting their PPE? And so on and so forth. Trends are very important because if we pick up on trends, those are even earlier indicators of near misses. And near misses, we know, is an early indicator of accidents waiting to happen. We then know we should also attend health and safety committee meetings. If the workplace has 2 or more representatives, a committee meeting must be held at least once every 3 months, though many high-risk workplaces meet monthly. Be prepared for your health and safety committee. Bring your inspection reports and employee complaints to the table. Then it is time to consult and speak with the fellow health and safety reps and employer representatives. Use this time to talk to management about safety budget, training needs, or any policy changes. And then lastly, document everything you do. Committee meeting minutes are extremely important. Ensure your concerns are recorded in meeting minutes. This is your legal protection. Then from an employee engagement and communication perspective, again, you are the bridge between the workers and their bosses. This is where things like toolbox talks come in. You can conduct or participate in short 5 to 10 minute safety briefings with your team. Listening is very important during this time. Take the time to talk to your colleagues. They often know about workarounds or broken equipment that management hasn't noticed yet. Those near misses, those small things create a big difference in the long run. And then lastly, encourage reporting. You cannot do your job if you don't know a hazard exists. Remind staff that reporting a near miss today prevents an injury tomorrow. Now we are moving into the psychology of health and safety, the MES or Mindset Evolution Schema. The OHS Act lists duties for employers and employees like Section 14 that requires employees to take care of their own health and safety. And this is where we introduce the psychology of safety or the Mindset Evolution Schema, the roots to fruit model. The MES levels describe what the coach is doing and not who the person is. Now, in the Mindset Evolution Schema, we utilize 5 distinct levels in order to achieve safe mindsets and safe behaviors. So, in our first level, we look at behavior adjustment. And here we ask the question, what needs to change or be reinforced now? So for example, if people are not participating during your evacuation drills, that is a mindset and a behavior that needs to change. And we start at the first level to try and change that behavior outright. If we do not succeed in changing the outright behavior, we need to take a step back to level 2 of the MES. Level 2 of the MES then tells us if we are unsuccessful in changing that mindset and behavior, we need to look at knowledge and empowerment. And we can ask, what does the person need to understand about the task and themselves? So we know we want to adjust the behavior where people take fire drills more seriously, but we need to ask ourselves the question, do they actually know the right procedure? If they don't know the right procedure, we can't expect them to change the behavior. So in level 2 of the MES, we educate and we empower the individuals to understand how to conduct an evacuation drill effectively. If that still doesn't work, we need to take yet another step back to level 3 of the MES, which is perception exploration. What belief made this behavior make sense to them at that time? So maybe they know exactly how to do the fire drill or evacuation drill, but they still choose not to. This is what we call a limiting belief, where they value one thing over another. This is where they value their work over their own personal safety and think work is more important than evacuating the building. This is where we need to challenge that belief, where we rephrase that belief to say that safety is productivity. Because if you sit at your desk and it's not just a drill and you end up getting hurt, who is going to pick up your slack? All of a sudden, you are no longer productive. So we changed and reframed that statement to say to them that productivity equals safety. And the 5 minutes you spend on a drill now can save you weeks of time loss in a real event. If the perception exploration step doesn't work, that might mean that you don't have rapport or relationship with the individual. Then, you guessed it, we take yet another step back where we look at level 4, rapport cultivation. Think about the new safety officer starting off at your work and now all of a sudden dictating to you what you need to do for safety. That's not going to sit well with anyone. If you don't have a relationship and you don't have rapport with an individual, trying to change mindset and behavior becomes extremely difficult to achieve. So what do we need to do here? We take a step back and we listen and we introduce ourselves to the individual and build that relationship and, more importantly, build that trust. So once the individual sees that we are not here to dictate, but rather to encourage a safe working environment, then the trust and relationship builds. That rapport gets cultivated, and then that makes our perception exploration, knowledge empowerment, and behavioral adjustment so much easier. However, we must realize and make peace with the fact that not everyone will like us. And if that's the case and you can't build rapport with a specific individual, we take one last step back to level 5, which is influence network. This is essentially where we influence other persons to influence the delegate that we want to change the mindset and the behavior. Because we don't have the relationship doesn't mean that others has the same lack of relationship. Maybe they have a friend or other colleague that they see as an inspiration. We then work through that colleague or through that manager or supervisor to get to our delegate in question. So by utilizing the MES framework, we move beyond simply complying into the realm of creating a safety identity. So how can a health and safety representative incorporate the mindset evolution schema into their day-to-day activities? One of the key items to look at here is the observation hierarchy or job safety observation. In traditional systems, a SHE Rep might just check if a worker is wearing a hard hat. In the integrated MES model, the health and safety rep uses a job safety observation to look a bit deeper. Now, how does this work? From a risk control perspective, they identify what risks the control is protecting. Then they look at trait identification. They interpret the behavior they see. For example, if a worker followed a difficult safety procedure, the rep identifies traits like discipline or accountability through the job safety observation. Then we look at identity reinforcement. Instead of just saying good job, the SHE Rep uses coaching language to reinforce the worker's identity by saying things like, you lead by example when you protect controls. We can also use the committee as a cultural reflection room. Integration changes the nature of the health and safety committee meetings, where we look beyond statistics. Instead of just reviewing incident counts, SHE Rep leads the discussion on trait patterns and behavioral trends. And they also focus more on recognition. The SHE Rep uses the committee to formally recognize employees whose behaviors align with the company values. And then lastly, we also have the maturity stage management. The SHE Rep must recognize which maturity stage their team is in to adjust their approach. It is not a one-size-fits-all solution. First, we have the resistance stage. The rep here focuses on one high-risk task to demonstrate the value and build curiosity amongst the rest of the team. Then we transition into the delegation stage. If the team tries to pass the buck to external consultants, the SHE Rep steps up to take visible ownership of decisions to shift responsibility back inside the company. And lastly, this then transitions into an ownership stage. In the final stage, the health and safety rep mentors, supervises, and leads the system independently, proving the culture is self-sustaining. Then in conclusion, becoming a health and safety representative is a commitment to being the eyes and ears of the workforce, serving as the vital link between employees and management. This course has detailed the legal foundation provided by the Occupational Health and Safety Act, which outlines your rights, your protection from civil liability, and your essential functions in maintaining a safe work environment. Throughout this training, we have explored the critical shift from reactive to proactive safety management. From proactive prevention, by understanding the Frank Bird triangle, you now recognize that addressing the 600 near misses at the foundation of the pyramid is the most effective way to prevent major accidents and incidents from happening. Active oversight. You are equipped to perform monthly physical inspections, manage risk assessments, and lead incident investigations to identify trends before they even result in harm. Then cultural leadership. Beyond mere compliance, the MES or Mindset Evolution Schema empowers you to move past simple behavior adjustment towards cultivating a culture of ownership and shared values. If you are interested to learn more about the Mindset Evolution Schema, we have a wonderful course available on our Learner Hub called the Mindset Evolution Schema Behavioral-Based Safety Program, the Roots to Fruit Model. So be sure to check that out if you want more information on the MES. And lastly, effective representation. You understand how to utilize Health and Safety Committee meeting minutes, not just for reviewing statistics, but as a cultural reflection room to recognize excellence and drive continuous improvement. Your role is fundamental to ensuring that every person at your workplace returns home healthy and safe. By applying these principles, identifying hazards, encouraging a reporting culture, and reinforcing safety as an identity, you are ensuring that the workplace remains not just compliant with the law, but a truly safe environment for all. Thank you for watching today's presentation. If you found this content helpful, please consider leaving the video a like and subscribing to our channel. It really helps us a lot, and it takes quite a lot of effort to make this type of content freely available to our community. But we strive to keep you as the viewer educated and empowered. And that being said, as always, stay safe, stay inspired, and until next time, take care.